I don't use this channel to promote myself, so understand that while this video is going to be about a service I happen to offer, I'm promoting the service itself, regardless of who provides it, as long as that service is being provided by a skilled arbitrator-mediator. It's a combination of arbitration and mediation, or Arb-med for short, that I'm going to talk about. First, why do I recommend Arb-med for divorce cases? Well, to make resolving divorce cases faster, less expensive, and less emotionally and mentally frustrating. It is taking months after the discovery and pretrial periods have expired to get a trial date in divorce cases, at least in my jurisdiction. That means that while you are ready for trial, you must wait for a date to free up for the court to try the case. It's unnecessary to wait that long. With rare exception, a divorce case can and should go from start to finish, including the discovery and other pretrial phases, in less time than it takes to wait for a trial date. If you don't want to wait for months to get to trial, Arb-med is, frankly, a better option than trial, and saving time is just one of the many improvements Arb-med is over trial in court. Many ask if Arb-med is a typo. Don't you mean med-arb, mediation, followed by arbitration? It's not. Arb-med is that way by design. There are many good, even obvious reasons for arbitration followed by mediation as opposed to mediation followed by arbitration. For example, the parties agree in their Arb-med contract that the arbitrator's decision is not binding unless and until the parties do not settle in mediation. By using the same person who serves as arbitrator as mediator, that person has a far better understanding of the case during the mediation phase, which can only benefit the parties in mediation, and shorten the mediation, by the way. By holding the arbitration part first, there is no risk of the parties disclosing anything confidential to the arbitrator, as would almost certainly be the case if arbitration followed mediation. Arbitrating first preserves the integrity and trustworthiness of the whole process. The parties are motivated to prepare far better than going to mediation first. Knowing they need to make their best case in the arbitration phase, they have all of their documents and witnesses ready. They prepare for the questions and arguments to be made. They have a more realistic knowledge of the strengths and weaknesses of their case as a result of preparing for and going to arbitration first. The parties go into mediation after the adversarial litigation process, or arbitration reality check, clarifies just how strong or weak their respective cases are. Consequently, they have a more realistic understanding of the strengths of each case on both sides. They are in more of a mind to try to settle rather than to have the already existing but not yet binding arbitration decision imposed on them. Arb-med takes substantially less time to schedule and to hold without sacrificing the thoroughness and quality of the hearing. It saves money over preparing for and going to trial and results in a final enforceable order. If you believe Arb-med could be the right fit for a pending or future case of your own, or to have any questions you may have answered, please call or email us at 801-466-9277, and you can email me at eric@divorceutah.com. Be warned, Arb-med is not well known or well liked among most divorce lawyers, so while I certainly have no objections to you asking around about Arb-med to get a variety of viewpoints on it, if it sounds like a good idea to you but not to the attorney or attorneys you consult with, make sure the attorneys that you have spoken with have had some experience with Arb-med so that you know whether to take what they have to say seriously.